The, we'll finish up with the sad story of Houchins versus KQED, and then bring it up to date about the extent to which the First Amendment provides a right of access to government information and facilities. The decision was about a toss-up, 3 to 3 to 1. But both of the ambiguities that had been left in the law by Stewart's opinion in the Pell and Saxby cases were resolved in the KQED decision. That is, that the press does not have any superior right of access to government information superior to that of the general public. And that neither the press nor the public has any First Amendment right, not just to a jail, not just to government facilities, but to information within the control of the government. That was a pretty bleak result and First Amendment setback. But there was a little bit of a silver lining in that Stewart's concurring opinion, while agreeing with the broad propositions of no greater right of access for the press and no general right of access for anybody, he said that if government opens the door and allows the public any kind of access, then the press is entitled to sufficient access to do its job, to report the news effectively, which he italicized. And he spelled out that that meant, in the context of this case, that the access of the press must be effective, that they be able to get into the facility when something happens at reasonable times so that the news can be covered, not on a monthly guided tour basis, but when news breaks, the press should be able to cover it. Moreover, the electronic media, television, radio, should be able to use their cameras and recording equipment so that they can cover the news effectively. But, Stewart said, they still won't have access to sources of information or places that the general public doesn't. And that meant, in the jail case, that the press would not be allowed to go to the little Greystone maximum security part of the jail, which was the center of interest. But the public wasn't allowed to go there, and therefore, Stewart reasons, neither is the press entitled to go there. And since the general public was not allowed to interview prisoners, neither was the press. That's the way Stewart came out. The case was remanded to the district court for whatever further proceedings might take place, and turns out that the sheriff didn't want to quit with the public tours, that he found that they were good public relations and got him some political capital. And so he continued to have the monthly tours. And we then seized on Stewart's concurring opinion to say, look, they're allowing the public in there, therefore KQED and the press must be allowed effective access, come in, bring their cameras, and come in and cover the news when it happens. And we were able to settle the case on that basis, with the parties agreeing that that's the kind of access that would be allowed. Not exactly a triumph, and the fact that KQED got most of what they wanted out of the case doesn't help when you consider the magnitude of the First Amendment loss by the court saying that there's no such thing as a First Amendment right of access to government facilities or information. The dissent by Justice Stevens on behalf of himself and two others was eloquent. It reasons that information gathering is entitled to some measure of constitutional protection. That is, the conduct of gathering the news, as opposed to publishing the news, the conduct itself in gathering the news, the ability to go someplace, is entitled to some constitutional protection. The majority wouldn't disagree with that, but then the logic goes on, Stevens' logic goes on to conclude that an official government, an official prison policy of concealing information about what goes on in there from the public by arbitrarily cutting off the flow of information at its source abridges the freedom of speech and of the press. That, of course, is a proposition that the majority of the court did not agree with and is not the law. I didn't realize until just a few years ago how close we came to winning that case. A graduate student here at Cal pointed me to a book by Professor Bernard Schwartz called The Freedom of the Press. And for his book, he got access to some of the confidential papers of justices who had retired or died. And he found the scorecard that one justice used when they voted on this case. And it turns out that the vote in the case was 4-3 in KQED's favor. And the writing of the opinion was assigned to Stevens. And he proceeded to write a draft opinion and circulate it among the justices, an opinion that must have looked very much like his dissent. And what happened was that Stewart, when he saw the draft, got cold feet, said he couldn't go along with that opinion, and switched sides. So instead of 4-3 in KQED's favor, it became 4-3 in favor of the sheriff. So it was a close call, but I have to say, you should know that it's still the law, the KQED decision, that there is no general right by either press or public to government information. That's not, however, the end of the story on a First Amendment right of access to something, because just 2 years later, the court decided the Richmond newspapers case, 1980, which involved a murder trial in Virginia. It was actually the fourth trial for murder that this particular defendant had been subjected to. He was convicted once, was reversed on appeal, sent back for retrial. There were a couple of mistrials, and so they're starting again for the fourth time. And the lawyer for the murder defendant made a motion to the judge to clear the courtroom. Everybody out of the courtroom except whoever's on the witness stand and the clerk, the lawyers, because it appeared that in one of the previous trials there had been some improper shuttling of information between spectators and witnesses still to come, telling witnesses still to come what a prior witness had testified to. And so the defense lawyer said, let's clean it up. Nobody should be here. And the prosecutor didn't object. And so the judge ordered the courtroom cleared. No spectators, no press. And the trial proceeded in secret behind closed doors. There were two reporters from Richmond newspapers in the courtroom who objected to being evicted from the courtroom. And they got their lawyer down there in the afternoon who told the judge that they objected and asserted that they had a First Amendment right to be there. The judge said no, and the trial proceeded. The defendant was acquitted. That didn't matter. The issue had been preserved, and the newspapers took the issue to the United States Supreme Court, which decided in 1980 that closing the trial to both the press and the public violated the First Amendment. And the opinion in the case, the main opinion, was written by Chief Justice Berger, who reasoned that there had been a 700-year history of access to criminal trial proceedings in the Anglo-American legal system, going way back into medieval England, sort of from the beginning of courts. Access to courtrooms for the purpose of observing criminal trials had been open. And he said that 700-year history of unbroken access to courts created a presumption that access to courts should be open, couldn't be closed. I put up a picture of Independence Hall in Philadelphia. How many of you have been there, where they wrote the Constitution? A few, good. That's what it looked like when they wrote the Constitution. And when they wrote the Constitution, the doors were closed and there was a guard stationed there so that nobody could get in. And the Constitution was written behind closed doors in secrecy. No reporters, no spectators, no clerks, just the delegates to the Constitutional Convention. But right across the hall from the room where they wrote the Constitution is a perfectly preserved 18th century courtroom. Remember seeing that? And anybody who walks in the building, on the left is where the Constitution was written. On the right are three huge arches and no doors at all. Anybody who walks in the building can walk into the courtroom and observe what goes on there. And I thought that was an eloquent architectural statement about openness of the courts. And Chief Justice Berger, in his opinion in the Richmond newspaper's case, said that that history of openness created a presumption that the courts, at least in criminal trial proceedings, ought to be open to press and public, not distinguishing between the two. But that's not enough. That history was not enough. The opinion said that in addition to looking to history, a court that's considering closing a courtroom should look to the functional or utilitarian or practical values of openness with regard to this type of proceeding. And Berger identified three. He said that allowing press and public to observe what goes on in a criminal trial is important to the process itself in that it provides some assurance that the trial will be conducted fairly. It will discourage bias by judges, for example, and it will discourage lying by witnesses if people can observe what the witnesses are saying. It discourages perjury, and that assurance that the proceeding will be conducted fairly is an important practical value of openness. And then secondly, openness promotes the public's acceptance of the use of the courts as the way we ought to resolve disputes. The openness has an educative value, informing the public of how the system works, and that it works. And finally, openness in criminal trial proceedings serves a kind of therapeutic value, what Berger called a cathartic value, in providing some kind of release for the public to see that justice is being done. Here's the outcome of what happens when you commit a crime, and the public can see justice being done. So the court concluded, in light of both the history and the functional values of openness, that there is a First Amendment right of access to criminal trial proceedings, never mentioning the KQED decision, as though it had no relevance to that conclusion. Justice Stevens wrote a concurring opinion saying, well, this is certainly a landmark decision in the Richmond newspaper's case, but it's inexplicable why we didn't do that 2 years ago in the KQED case, where they're talking about access to a closed institution like jail rather than courtrooms. It was a watershed decision. That was followed, the Richmond newspaper's case, by 3 other cases in the 1980s, all involving access to criminal-type proceedings in the courts. The first in 1982, the Globe newspaper case, involved a Massachusetts law that required judges to clear the courtroom in cases involving minor sex victims. And that issue went to the Supreme Court, which decided, based on the reasoning of Richmond newspapers, that there shouldn't be an across-the-board blanket prohibition on public and press access simply because the case involves a minor victim of a sex offense. That the courtroom can be open generally, and maybe it'll have to be closed for a particular witness's testimony, but there shouldn't be a general closure across the board. Then in 1984 and 86, the court decided 2 cases from California, both involving the press enterprise down in Southern California. The first one, in 1984, involved the voir dire of prospective jurors in a death penalty case. Voir dire is the name of the process used to question prospective jurors to see whether they can be fair and impartial in the case. Have any of you served in a jury? Did I ask that before? No? So you haven't been through the process. Well, yeah. they ask you questions about whether you know the parties and whether you have preconceived views on the case, whether you've been exposed to any media coverage of the case, and so on. They want to make sure that you are untainted and can be fair and impartial. And in a death penalty case, they make extensive inquiry into your views about the death penalty. And the prosecution is entitled to a jury composed of people who would at least entertain the possibility of imposing the death penalty. If a prospective juror says, I'm against the death penalty and I wouldn't impose it, that juror is disqualified. Well, anyway, the judge in one of these serial murder cases down south decided that this was a sensitive subject, that the prospective jurors were reluctant to testify in front of a whole bunch of, to answer questions. They're under oath to testify truthfully. They're reluctant to disclose much about their beliefs in front of a room full of strangers. And so the judge cleared the courtroom. Press and public evicted. And the press enterprise took that to the Supreme Court, which decided, based on the reasoning of Richmond newspapers, that the judge had no power to bar access by press and public to this criminal trial proceeding. This wasn't the trial. It was the jury selection process. But the court found that there was a history of openness, even of jury selection, and that the functional values applied as well. That was the first press enterprise case. The second one was a little bit more of a stretch. That involved a preliminary hearing in a serial murder case that was also a death penalty case. The preliminary hearing is a procedure used in California and many other states to determine whether there's, so the judge can determine, without a jury, the judge can determine whether there's enough evidence to subject the defendant to trial. It serves the same function as a grand jury, the screening device. And the preliminary hearing in this serial murder case was heavily covered by the press, and the judge was afraid that the testimony given in the preliminary hearing would be reported in the press and would contaminate prospective jurors who would serve at trial, because they would have learned of some of the evidence, at least, that was presented in the preliminary hearing. So he cleared the courtroom, press and public, out of here. That the press enterprise took to the Supreme Court as well, and the court once again decided in favor of openness. Here, the court didn't emphasize the history of openness of preliminary hearings, because there wasn't much history. That was a 20th century innovation and is not shared by all states. So there wasn't a strong historical case to be made that preliminary hearings have an unbroken history of openness. But the court emphasized the functional values that had been identified in Richmond newspapers and pointed out that in many cases the preliminary hearing is the whole show, because once the preliminary hearing is concluded, there usually is some plea bargaining, and the defendant might plead guilty to something, so there wouldn't be any trial. So the preliminary hearing would be the only thing that the public and press could see, and it wasn't right to close that down. So the court decided that preliminary hearings couldn't be shut down to the press or the public. The Supreme Court has not touched that issue since 1986. That's the last word on the extent to which there's a First Amendment right of access to anything, as far as the Supreme Court is concerned. And you can take it as the law that, under KQED, there's no general right of access by either press or public to government facilities, information, or proceedings. But there is a First Amendment right of access to at least criminal trial proceedings. Following that line of decisions, the California Supreme Court, in a case involving the NBC subsidiary in Los Angeles, decided, this is a case involving Clint Eastwood. It was a litigation between Clint Eastwood and his former mistress. They had a bunch of business deals in addition to their romantic relationship, and all relationships fell apart and they're suing each other. And it was a big tabloid-type magnet in Los Angeles Superior Court, and all the tabloids were covering it, and the judge didn't want the jury to be contaminated by what would be reported in the press, and he therefore ordered press and public evicted, except in times when the jury was actually in the room, so that all of the proceedings in the case that were conducted without the jury being present, and there were a lot. There was argument about what evidence could be presented, what the instructions to the jury would be, a lot of housekeeping details that the jury didn't need to hear, and in many cases shouldn't hear, and the NBC subsidiary objected to being excluded from the courtroom. That went to the California Supreme Court, where the question was, does the reasoning of the Richmond newspapers' precedential line of cases apply to civil cases? This was a civil case, not a criminal case. And sure enough, the California Supreme Court found that there was an equivalent history of openness of civil cases in the Anglo-American legal system, and that the functional values identified in the Richmond newspapers case largely applied to civil cases as well. Had an educated value, discouraged perjury, discouraged bias, and so on.